Jersey contracts. All right, so a couple of things you guys are going to have over the weekend. You're going to have the chapters for New Jersey. I know we're doing the PowerPoints, is just to make sure we cover what's specific to New Jersey, as I said. But you're also going to have the questions for these 2 days. I just didn't feel like it was fair to give you questions after 3 chapters through PowerPoints. So I want to make sure the chapters are there and the Q&A as well. Okay. I think I'm missing 2 days of class replays. So I'm also going to put that there. And math, you guys got over 50 questions there, so you can practice. It's going to be very exciting. There's only up to 8 questions in the state exam, but the 50 questions, because I know some people panic. Oh, it's math, right? It's not that hard, but it's not that hard once you understand how to break it down. And that's what I'm going to show you on Monday. Okay. It's not that hard because our math does not involve anything crazy. It's real estate, right? The biggest thing you need to worry about is how to do your commission, right? That's it. So the commission calculations. Anyway, but the questions are a little tricky. Yes, so they're a little tricky. So what I'm going to show you is not how to, I'm not going to teach you math on Monday. I'm going to teach you how to read the questions, extract info, put it in the calculator, get the answer, and move on. Because I can't teach you math. You're all adults. 1 + 1 is 5, right? Yes. It's basic math. All right. So today we're going to go over contracts for sale in this particular chapter and listing agreements. In the next chapter, we'll talk about leases as well. So it's part of contracts, but there's a few more details that we address there. Sal, make sure your camera's on, please. Today I got my new contact lenses, so I can see you guys, every single one of you in detail. So you cannot run away from me. All right, get on camera. All right, so contract for sale. So you guys know, again, that this is like a review of the national portion, but then going in detail to what's specific to New Jersey, right? So contract handling, who can prepare contracts? Licensees can prepare contracts, but we're not attorneys, right? We are not attorneys. So all contracts that we are allowed to prepare, this is national law, but some states allow you to go a little bit further than other states. New Jersey says the only contracts we're allowed to prepare are residential. Look how it's underlined. Residential. No, Stephen, those are the PowerPoint numbers. I already corrected that. It's just that I had the New Jersey portion reserved to be 24 and on, or 24 and on, but we wind up shortening the national portion. So this is, you did chapter 21, 22, and 23, which would be the 24, 25, and 26. But that's what the PowerPoint says. I already corrected that. It's 23, 24, 25, and 26 today. All right, so what contracts can we prepare? We can prepare residential contracts only. Residential contracts, okay? Commercial contracts, who prepares them? Attorneys. Crazy contracts, like option contracts, like land contracts, anything that's a little off, like unusual, that's why I called it crazy, anything unusual, attorneys prepare. The only thing we're entitled to prepare are these. Why? Because these come in pre-printed forms. Okay, and you already know this from the national portion. I'm just reiterating here in the Jersey. Micah, whoever's there, kick him out. I told you my contacts are working. You're a little tiny box on the screen, but I see the mouth running. I see you're talking. All right. So pre-printed forms, that means we're not drafting contracts, we're just filling in the blanks. That's all we do. Okay. That's your daughter? Kick her out. All right. unless she wants to take the class, and that's different. Now, licensees can use pre-printed forms, but may make modifications which must be initialed by principals. Now, the modifications that we can make, guys, it's as simple as what I'm doing here. We can cross some stuff out. Okay, that's all we can do. We cannot alter the composition of the contract itself, but we can cross some stuff out that's not applicable. Now, me personally, I don't cross anything out. I fill in the blanks, I do all the check boxes, whatever, send it over to the attorneys, let them say, hey, not applicable. Let them cross it out. They're the attorneys. That's why we have something called attorney review. You got to remember that anything you handwrite takes precedence over printed provisions. So the way it works is you have a pre-printed form. Let's assume this is the pre-printed form. If you type something on it, it takes over whatever's on it. If you handwrite something, it takes over typed and printed. So priority, handwritten. Then you have anything that's typed into it, and then whatever the contract is as a standard, okay? How do we handle contracts? We got to deliver a copy to every principal, okay? And that's immediately upon signing. So let's say there's 10 people to the contract. Let's say seller and the buyer, right? On each side, there's like multiple people. We're at the closing table, right? Or we're at the contract table, or we're at the listing table. It doesn't matter what you're doing. Any type of contract, any type of agreement, everybody must receive an original duplicate right there and then. What does this mean? It means that all principals will sign copies in order to have original signatures. So I'm going to give you 10 blank copies. Blank meaning signature blank. Everything filled out, everything is good. You sign an original and pass it along. You sign an original, pass it along 10 times. So this way I have 10 original signatures in every single document. Does that make sense? So it's not like, hey, sign 10 times, we're going to make 10 copies. No, I give you 10 copies of the document, so you sign 10 times. If it's 5 people, I'll give you 5 copies of the document, so you sign 5 times, and so on. Okay. Document retention. Okay. Sorry. Here, I want you to write unaccepted. Unaccepted. Brokers must keep unaccepted offers for 6 months. Brokers must keep unaccepted offers for 6 months. Elvis is asking about, what about e-sign? Oh, e-sign is already an original because you receive a copy. As soon as everybody signs online, the final person signs, you receive immediately a copy of it. The thing about e-sign is that it's stamped to your location, to your device. There's an encoding there that says where it was done. That's why we don't have any clients sign on our computer or with our email. Never do that. Send it to client. They can do it from their smartphone. They can do it from their computer, whatever. Not on my computer, because it's specific to your address, your IP, internet protocol, right? So it's your IP address. It's to your operating system, to your documents that you use, document signing application. Everything is specific to you, to that moment. Okay, so once 10 people do it, it's the same as 10 originals. They receive automatically their copy. All right. Brokers must keep unaccepted offers. Please write unaccepted offers. I apologize, my mistake. Unaccepted offers for 6 months. 6 months. So let's say 5 people put a bid on property, right? 5 people put a bid on the property. But I accepted 1, of course. There's only 1 person that can buy. Okay. We accepted 1. I must keep the other 5 offers for up to 6 months for several reasons. But can you guys give me maybe an idea of why I need to keep it for 6 months? Why would I need to keep somebody else's offer, unaccepted offer, for 6 months?
you have to check, but it's things that quality touch,
Okay,
you know.
but it's unaccepted. I did not accept it. Yeah, it's unaccepted. So let's see. Guys, make sure you don't send anything directly to me. Keep it open on the chat. Change to open to everyone. All right. In the case the original falls through, Masha, okay. Ashley says for records, to keep a record, okay. Jefferson says they might accept it if the other offer falls through. In case it doesn't go through, in case it falls through, paper trail, cover your assets, to reach back out if the offer doesn't go through for legal purpose, obviously. Record, they can also be used and turned to contacts. I like the way you think, but the law doesn't care if you're using attorney to contacts. So what do you think it might be other than just for record purposes? So we did talk about fair housing, right? We're going to go over that again in the next chat, in the next PowerPoint. We talked about fair housing. What is fair housing? Fair housing. I'm not speaking German. Fair housing. Fair housing. Equal rights. Thank you. So the reason why we have to keep them for 6 months, the main reason we have to keep them for 6 months is that if there's any complaint that you chose a contract over another, right? You will be on those copies. Because remember, in New Jersey, I remember actually in fair housing, you have up to 1 year to file a complaint with HUD. You got 2 years to file a lawsuit. You're going to learn the next chapter that in New Jersey, you have 6 months to file a complaint, 180 days to file a complaint due to discrimination. That's why we keep them for 6 months. It's a discrimination issue. Why did you choose that contract and not another contract? Okay, got it? Now, what if the contract was, no, the 2 years is for lawsuits, Stephen. I'm glad you brought that up. I will address it in the next chapter. The 6 months is for complaints, just like federal law says 1 year for complaint. Lawsuits, 2 years statute of limitation. Okay. Complaint for investigation is one thing, lawsuit is another, guys. Yeah, well, if they sue, yeah, you will need it. What the law is saying is that they require, just in case somebody complains. As a standard practice, you should keep everything on file for up to 6 years to cover your assets. Okay, you should. In fact, if it's an accepted contract, if you accepted it, offer, it became a contract. So you got to keep it for 6 years because this is the statute of limitations in New Jersey. Okay. Huh? I love how you talk to yourself. I never know if she's asking a question, if she's saying something like, sure. I'm like, what? Never know. All right. So contract handling. Dual contracts are prohibited. So what is a dual contract? A dual contract is when you have two contracts for the same property with the same seller, with the same buyer. So it's the same transaction, but one has a higher price, the other one has a lower price. Now, this is a common practice in the car industry. When you buy a car, the dealer sends to the bank something of a higher price so they can get more money. Usually they put fluff fees into it that have nothing to do with what you're really paying for. But that's what it is. It's for you to get a bigger loan. New Jersey says if you're selling the property for 50K, then the price that goes to the bank is 50K. If you're selling the property for 100K, then what goes to the bank is 100K. You cannot have two different types of contracts. That is illegal. Okay. You cannot make an actual contract and a duplicate for a higher price in order to get a bigger loan. This is New Jersey specifically. Some other states have adopted it as well, something similar to this, because it's fraud, right? You try to get more money from the bank when that's not the real contract. Anything that like that is fraud. Okay. General contract requirements. New Jersey requires a plain language in the contract. What does that mean? It means that sales contracts, listings must be simple, clear, and understandable. New Jersey requires that because there's no requirement for you to have an attorney. So if you don't need an attorney to get into a contract, right, you should be able to read the contract and understand the terms and the conditions of the contract. Does that make sense? All right. And no fee schedule, you guys already know. Commissions are negotiable, so you cannot say it's a set percentage. Okay. So every listing must include a commission negotiability statement. If it's a commercial transaction, we don't prepare contracts, we prepare a letter of intent, LOI. We simply say, hey, I would like to buy your property for X amount of dollars at these terms. That's it. It's a simple email. It's a simple letter. All we're doing is expressing our intent. Okay. If approved, then we bring that to an attorney. That attorney will draft the whole contract. For commercial properties, letter of intent only. All right, next we got rescission. What is this word, rescission? Rescission. I've mentioned it a million times. What is rescission? What does it mean? Take it back. Okay. So take back, that's rescission. Back out. Okay. Take it back. Wasn't that reversion? Rescission. Huh? Say it. Yeah, you're getting there. It's gonna be a tough one with you. Speak up. Say it. It is backing out. It is giving up. It is canceling a contract. Rescission means cancellation. Cancellation. We're saying, nope, don't want it. Back out. Okay. It's not taking back because we're not taking anything back. We're just saying, I don't want it. Giving up, canceling. Now, can you cancel a contract? Can you cancel a contract? Yes or no? The actual answer is depends. Depends on what stage we're in. Depends if there's conditions. It depends. See, it says right here, if there's fraud or misrepresentation. So if you find out something that's not true about the property, can you back out? Yes. Okay. It's subject to Full Disclosure Act. If it's a development, remember, if it's a development or if it's an out-of-state property or anything like that, that's extreme, like 100 lots or more, right? You got to give a public offering statement, a POS. You got to give 7 days of cancellation or rescission. So if it falls under that, you have the right of rescission. Now, the only other way contracts can be rescinded is based on contingencies like mortgages and anything like that, right? But that only happens after attorney review. Yes, Elvis. So do you guys remember the cooling off period? We talked about that in contracts, the national portion. And I said that in New Jersey, our cooling off period is called attorney review periods. In New Jersey, cool off period is called attorney review period. This is where you have 3 business days. This is very important. 3 business days in New Jersey, unless it's a out-of-state property, a timeshare, or a large development, which requires the 7 days that I just mentioned earlier, right? But if it's a regular residential contract, we have 3 business days to just say, you know what, Milton, I like your house, but I'm out. And Milton's like, oh no, you got to give me a reason. You put an offer, I accept it, we're under contract. I don't have to give you a reason if I'm within the 3 business days. Beyond the 3 business days, Beyond the 3 business days, we're under contract and everything else comes into play. All the other contingencies and clauses. Let me know if you got it. Say yes in the chat or say no if you want me to explain again. Yes in the chat. Thank you, Steven. Masha, you speaking Spanish now? All right. So here's what happens. Depending on the type of contract, you might be able to send just a written cancellation within 5 business days. Most contracts require you to have a inspection period. Okay, so if you're within the inspection period, like the 14 days, you have the right to send a notice and say, hey, I'm within the inspection period, not happy, I'll walk away. But with that comes certain consequences. So I've just put it here to let you know, with that comes certain consequences. You might still be liable. You might still be liable for any costs to the seller. Okay, any delays or costs that the seller might have had. Statute of frauds. Every state, if you guys remember, has a statute of frauds. This is where they are explicit about their rules regarding contract handling or negotiations. So one of the things that they say is that certain contracts must be in writing, to be enforced. It's not that they're not valid. It doesn't talk about not being valid if they're not in writing. What it says is to be enforced. So if you want to take me to court, you better have it in writing. Okay. So contract for sale is one of those contracts that must be in writing. Commission agreements. You want to get paid commission? Must be in writing. And then there's this one. Leases for 3 years or longer. If you guys remember in the national portion, we said traditionally 1 year or longer, right? Jersey allows leases of 2 years to be verbal leases. Leases up to 30 years to be verbal leases. But if it's a 3 year or more lease, it must be in writing. So New Jersey says 3 years or more. Three years or more. Now, I did say that some verbal contracts could be enforceable, right? I said you should have it in writing. In fact, some contracts like these must be in writing. But nobody said that an oral contract or a verbal contract is not valid. So if they are valid, we could go to court, right? The problem is that it's a little harder to get it to go through. So you have to have clear and convincing evidence. So oral contracts can be enforceable as well. So some of these can be enforceable. I forgot to put here. As long as you have clear and convincing evidence. So for instance, if I have witnesses, okay, unrelated witnesses, obviously, it becomes very difficult if you're the party to the contract and your witness is your spouse. Yeah, it's a little difficult. But if there's a third party, that's a witness. If you have correspondence that even though it's not a contract, but shows the intention of the party to get into the contract. Does that make sense? So if there's any type of email or text message or letter that says, hey, I want to buy your house for 500,000, right? And you at one point said yes, right? And there is a continuous exchange of information along the way, then the judge might be more lenient to allow you to go through with the contract because you show a pattern in that conversation. Okay? If there's nothing that shows in any type of communication, nothing that shows that you could potentially be getting into a contract, then sorry, USOL. Okay? You cannot get anything out of this. This is why I keep on saying, after you have a verbal conversation with somebody, put it in writing. all the time. I just got off the phone earlier with a wholesaler on the property that we're trying to buy, and right away I sent an email as soon as I got on the phone. Hey Audrey, per our conversation, this is what we agreed to. This is what I'm expecting. Let me know if there's anything that I left out. I'm not attacking. I'm just saying, please let me know if everything is right. Because now what I'm asking for is validation of what we just said. You see what I'm saying? I didn't go like, hey, you said, I said, we said. No, this is our conversation. Just let me know if I left anything out. Because now any reply is clear and convincing evidence. Does that make sense? So always. Oh, I don't know. I'm here. It was literally probably like 30 minutes before the class. Cover your assets always. All right, sales contract requirements. Just like the national portion, if you're buying a house, a property, land, whatever it is, if you're buying one, you have to include a description of the property. Guys, you know this was coming. If you see description of the property, what are we talking about? If you see description of the property, what are we talking about? The details of the property? No, we're talking about meets and bounds. Thank you. Lots and blocks, and there's one more. Rectangular survey system. Legal description. It's not the description of the property like, oh, it's a 2-family, 3-family, whatever. It's the legal description of the property. The legal description of the property. You have to remember that. Legal description. We have to include, obviously, the purchase price, an agreement to buy and sell, and what type of deeds we're getting ourselves into. You guys remember the different deeds that we can get into? Anybody? A what? A what? A general warranty deed, okay. Quitclaim deed, okay. Tax deed is a little different, but thank you. Mechanics deed doesn't exist. There's a special warranty deed or a limited warranty, yes, and there's one missing. We have the warranty deed, okay? We have the limited warranty deed. We have a quitclaim deed, and there's one missing, not the reconveyance deed. Nope. Jasmine for the win. Bargain and sale deed. Sorry, Shakira, she was too fast for you. What am I going to do with you? I don't know what to do with you anymore. She was saying it the right thing, but then under her breath, like say it. Just say it. All right, so let me address a few of the stuff that you guys said here. Reconveyance deed. So that's a transfer deed from the mortgage back to the mortgage company back to you. So the lender back to you, or the third party in this case, actually, reconveying it back to you. We're talking about between seller and the buyer, because we're talking about contracts for sale between the seller and the buyer. What contracts can we have? What types of deed can we have? Right, between the seller and the buyer, contract for sale. So the only deeds that we can have here: warranty deed, special warranty deed, the bargain and sale deed, or quitclaim deed. Now, Alexander, you wrote tax deed. Okay, the tax deed is a bargain and sale deed. Okay, it just happens to be between between the municipality and whoever's buying it, or like a sheriff's deed is also a bargain and sale deed between the sheriff and whoever's buying. Okay, but the categories of the deeds are general warranty deed or full warranty deed, limited or specific warranty deed, which is also called bargain and sale deed with covenants against Grantors Act, the straight bargain and sale deed, which is used in tax sales and foreclosure sales, and the quitclaim deed, which is for divorces, intra-family transfers, or when we're trying to correct an issue with a title, if you guys remember, right? When there's a gap in the title, okay, we use a quitclaim deed to fix that gap. All right? But keep on participating, guys. I love what you guys are doing. That is great because the more you talk about it, the more you exercise that muscle right there called brain, the more you exercise it, the better it's going to be for you to take the exam. Okay, so make sure you voice it out or type it out in this case. You got that, Alexis? Voice it out. Fernando, you too. You're doing great, but you stopped for a second. Just say whatever.
Sometimes it's because, you know, the pronunciation of the word that's.
Just say it louder because I if I don't hear you, if the issue is pronunciation, okay, English is not my first language either. So there's a few words that I also have trouble with. Okay. But the more you speak, the better it's going to be. All right. And if you speak it out, maybe I don't understand in the English, let's go and speak Spanish. All right. Let's go and speak Italian. Let's go and speak. There's a few things, a few languages I know how to speak or understand. So I'll work it out with you. I'll try. Your first boss was Portuguese? Oh, I feel sorry for you. I really feel sorry for you. I don't work for Portuguese people. The last time I worked for somebody that was Portuguese, this is like in 2002. I said, never again.
Yeah.
Never again. Yeah. Hmm? Work hard, yeah, absolutely. I was just saying that the other day to somebody. Reconveyance and trust deeds are bargain and sale. So here's what you need to understand. You got to understand the difference between the deeds. A full warranty deed saying you're giving a guarantee on that transfer. You guarantee the past, the present, future, right? A limited warranty deeds or special warranty deed, you're saying, hey, while I have the property, that's what I guarantee. Okay. You're asking me about reconveyance, Shakira, and trustee deeds. Let me ask you something. When did they have the property? They didn't, right? A reconveyance deed, they never owned the property or had the property or title to the property, like effective title to the property. They had a temporary hold on the property, right? So it cannot be a limited warranty or a full warranty deed because these come with guarantees. So a bargain and sale deed or a straight bargain and sale deed means I have an interest in the property. I have the rights to sell the property. Here, it's up to you to do the research on everything else. Does that make sense, Shakir? So what the trustee is saying when they transfer it is literally, I have the right to do so, either by court order or by an agreement that, like say the title theory states, or by an agreement that, hey, they paid off the mortgage, so I'm giving it back to them. But that's it. Other than that, okay, this is like Ponce Pilates. We're just washing our hands and be like, hey, you crucify him, not me. I got paid. That's all I want to know. That's what the trustee tax deed is. That's what the sheriff's deed is. That's what the reconveyance deed is. These are like, I got no responsibility here. We do have the right to it, but that's it. But no responsibility. And then there's the quitclaim deed where it says, I might own it. I might not own it. I might have rights to it. I might not have rights to it, but I'm transferring it. Okay. So that's the order. Full warranty, some warranty, somewhat of a warranty, and no warranty. Okay, good. All right. Contract requirements. We also have the time and place of the closing. When we're preparing the contract, this was the same in the national portion. When we're preparing the contract, we're saying, hey, on this date, we're going to close, right? I've been watching one of my friends do, he's an investor and he's a mentor. He's been doing TikToks. And every time he starts a video, he does this little jump, right? And now I just felt like I was doing the same thing as him. I got to stop this. It's the weirdest thing. I already told him, like, it's cute. Hey, guys. Anyway, so time and place of closing, we got to have the signature of the principals. It has to be in writing. And here's some optional provisions or also contingencies that we have. Financing. I'll buy your property if I get approved for the mortgage, right? I will put X amount of dollars as a first deposit plus X amount of dollars as a second deposit, right? Title. As long as there's a clear title, I'll buy it. As long as inspection is satisfactory, I'll buy it. If there's no offsite conditions issues, I'll buy it. Zoning, the CIS acknowledgement. So you guys remember what a CIS is? We spoke about it yesterday.
Customer.
Customer, yes, you're right. Go for it, say it. You're going back to notes, unbelievable. It was just yesterday. Am I the only one that remembers yesterday?
It's not, it's consumer.
Consumer information statement, yes. But that's what it means. I'm asking you what it is. I'm not asking what the acronym means. What is it? What does CIS mean? I'm asking, what is that document? By the way, for 7 years that I'm teaching this, everybody falls for the same trap. The question is always the same. What is a CIS? And they go like, consumer information statement. Like, yay, you know the acronym. What is it? It's disclosures. Is it a contract? Is it a contract? Oh, by the way, Katie, it's not just for the buyer, it's for the seller, it's for the landlord, for tenant, for everybody. Could be to the customer or to the client, depending on how we employ them after, or they employ us after, I'm sorry. So it's not a contract, it's simply a disclosure, correct, right? But now that we're on the contract, it says CIS acknowledgement. So the very first page, guys, of the New Jersey contract is called the notice to the buyer and the seller, all right, or option 26. It's a page that has to be there as a cover page to the contract that says, I represent you this way. See, the CIS was a disclosure. I could represent you if you choose to. Now we're in the contract, I represent you this way. One is I could, if we move forward, or I can, if we move forward, I will, if we move forward. When we got a contract or a listing, we're now saying, I am representing you this way, or I'm not representing you. Okay, so that's why we do an acknowledgement. We're saying now, yes or no to the type of representation we have. Speaking of which, what type of representations can we have? What do we describe in the CIS? What is described in that notice? What is described in that notice? The CIS is a consumer information statement. It's not a listing agreement. This is what happens when you miss one day of class. Look at that. Shakira, type of agency. Okay, that's a partial win for you. That's half a point. Let's get some more points. Okay, Nike. What type of agencies can we have? It shows fiduciary duties as well. So you get another quarter of a point. We can have dual agency, says Elizabeth. Correct. Dual agency is one of them. If we have dual agency, can we have single agency? All the single agencies, come on. What are they?
Seller.
The seller agency, yes. I could be a seller's agent and I can be a buyer's agent. Very good. If I can be for both, I can be for them individually. Yes. There's one more. What is missing? What is missing? We have seller's agent, buyer's agent, dual agent, and what else? We have the transaction or no agency. The transaction broker. I could represent the seller, I could represent the buyer, I could represent both, or say, hey, I don't represent you, I represent the transaction. That's all in the CIS. You got to know this. That's what's in the CIS. The types of agency relationships we can have. Okay. Another thing we have there is the liquidated damages clause. So I'm going to give you a deposit, right? We talked about it up here. And a deposit is for liquidated damages, meaning if the transaction does not go through because the buyer defaulted, the seller is entitled to keep the escrow money. Good? You guys good? Is this good or what? As a review. Right? So far, that's all it is. It's a review. Getting you ready for the exam next week, right? Who's going to take the exam next week? Make your commitment in the chat right now. I'm going to take the exam next week. And actually give me a date. Put in the chat right now the date, because I'm going to go back to this chat. I'm going to save it. Put a commitment right now. I don't want mights. I will. What date, Alexis? Gotta look at the calendar.
I will.
Next Friday, next Saturday, ASAP. Give me an actual date. Come on. Shalai says, what's deck? I don't know what deck is. I hope you're not saying December. I hope you're not saying December, Shalai. We're talking about the school exam, because you cannot go to the state without the school. So come on. What do you mean? There is an exam tomorrow for people that already completed or want to do it tomorrow. There's no exam next Saturday. It's tomorrow and then 3 weeks later. There's nothing. There's one tomorrow and then 3 weeks later. It fits on a Saturday. If you want to do it during the day, it's Monday through Friday. You can start at 10. You can start at 10:30. You can start at 11. All the way up to 2, you can start the exam. The school exam, yes. Make those commitments. Make those commitments right now.
Next Saturday will be 3 weeks.
3 weeks from now. Just a reminder, if you're waiting 3 weeks, it starts delaying. Hold on, it starts delaying your 60-day challenge. That's all I'm saying. All right. So I do advise, if you're doing the exam 3 weeks from now, make sure you have your fingerprints scheduled already, okay? Otherwise, it delays everything.
And then tomorrow's the first.
Ashley, just put it in the chat, in the website chat, just contact there and you'll get it. So, because we have to verify, and I cannot do it right now, we have to verify that you have full attendance, okay? Or 80% attendance. Some of you already contacted and we gave you the password, just check your email. But that's what you have to do. Shakira says next Friday. All right, Shanice says the 10th. The latest is 2 o'clock to start. Every day, Monday through Friday, the latest to start the exam is 2 o'clock. Okay. You have 10 o'clock, 10:30, and so on. Are we open on Columbus Day? These people. I don't know. I'll figure out. If I have somebody here, Shanice, we'll do it. I'm not going to be here on the 10th, so sorry. But if I have somebody here at the office, I'll see if they're able to proctor your exam if you want. All right. So here's what I want you guys to do next. Those of you that already made a commitment, congratulations. I want you to, as soon as we're on break, I want you to go to the chat in the school website. It's offline because there's nobody here right now to answer that. But I want you to write that date there. I want you to say, schedule the exam for this date at this time. Okay? And then we'll put you on the calendar. But make a commitment. Let's get this now. You can't? You can do the exam tomorrow. 10 o'clock in the morning. Tomorrow Saturday, 10 o'clock in the morning. I got 7 people doing the exam tomorrow. Let's see. If we have time, can you go over cap rate math question? We'll go over cap rate on Monday. If it's from the practice test, anything from the practice test, here's one of the things I want to tell you right now. Yes, it could be online, it could be in person. You just got to schedule it. You got up to 4 hours to complete it. Up to. Anything you do from the practice test, when you're practicing the exam that we have on the student portal, treat it as if you were in the state exam. No phones, no books, no distraction. Okay? When you're done, you receive the result of that practice exam. Okay? So Lacey, if there's a question there that you have doubts about, what I want you to do next, once you receive your email confirmation, once you receive it, take a screenshot of whatever your question is, put it in the group chat on Telegram, and everybody's going to answer it. Okay? We're going to help you. It's a group effort. This way, everybody learns. Okay? Fair enough? Love the commitment, guys. 60 days. So you're doing tomorrow at 10 o'clock in the morning? That's what I heard. That's what I heard. All right, keep on going. We got other requirements. Lead-based paint statement. You guys remember this? It wasn't that long ago. Lead-based paint. If a property was built before 1978, you got to remember that date. Heavily tested. The property was built before 1978. There's a high probability of lead because over 70% of homes back then were built with some type of lead or lead-based paint in the construction, right? Now, if the property was built before 1978, okay, not 1979, in case it's in the question, I'm just putting it out there. They will mess with you. Not 1979, it's 1978. Anything built before 1978. Lead-based paint, and you must provide the EPA disclosure pamphlet that says protect your family from lead, okay? Unless the buyer waives, we must give a 10-day right of inspection for lead-based paint. This is a must. Okay, so these right here, very important. Anything related to lead-based paint, very important for state exam purposes. And in real life, this is the only thing that in real life, if the property was built before 1978, it does not matter if it was rehabbed. Let's say we took all the walls, if we kept the structure, if it's not a complete knockdown, then it's a 1978 property. You still have to provide the disclosure. Okay, we could have gutted it. If there's part of the original structure, you need to provide that disclosure. It's the only thing. Okay. Notice to buyer and seller, I already addressed that. A binding contract statement. So you guys know that the attorney review is 3 days, right? All right. So we have to have a statement in the very first page of the contract that says this contract is binding and it will become final within 3 business days. So the statement must be there in all caps. Everybody must be aware that they have 3 days that they can bring that to an attorney or back out within the 3 days. After the 3 days, this statement says that after the 3 days, it becomes binding. So the terms are binding. That's why we have the 3 business day attorney review. Okay. It allows the parties to consult with an attorney. It allows the attorney to cancel within 3 days, or even ourselves within 3 days. Okay, property condition disclosure. Obviously, a property should be habitable, right? Okay, but we need to have a property condition disclosure statement that the seller fills out about known defects. Okay, about known defects. They must disclose it. They must be provided prior to making an offer. This is something that a lot of realtors fail at. Yeah, I'm going to tell you everything you guys fail at. I got a listing. Yes. Did you get the seller to fill out the property condition statement? No. So if you guys go to the MLS, I guarantee you that over 70%, and yes, I'm throwing big numbers out there, over 70% of those properties listed there do not have the seller's property condition statements. So when you go click on it, you might see pictures, you might not see pictures, because that's another one that happens. You might see the seller condition statement, you might not see the seller condition statement. Property was built before 1978, you might see the lead-based paint disclosure, you might not see it. The MLS enforces some of these. So if you fail to submit something to the MLS, they'll fine you. per day. Each MLS has their own structure, but these are requirements. You must provide it to every buyer or prospective buyer prior to the offer. That means it must be included in the MLS. You're gonna ask something, Fernando?
Yeah, I'm a little confused. I'm saying, in this contract, how about the flips houses? That's
What about it?
different, right?
What about it?
Because if you say the homes can be only to habitable, right?
Yeah,
So
so hold on, I'll cover that right now. If the property is being sold as is, because that's what a flip is,
Right.
I still need to know the conditions of the property. You still need to tell me. The house is falling apart. Okay, I'll buy it. I need to know that it's falling apart. Because if the house is falling apart and I'm paying $500,000 for it, when the property should be really under contract for like 100, then I was deceived, so I can walk away. Okay? That's why I need to be fully aware of all the issues with the property. I'll still buy it as is, but tell me what the issues are.
I mean, what we bought, couple properties, and when you see the picture, look like it was shape.
Mhm.
If you go there, very, really bad.
Yeah. Oh, the pictures are amazing. I've seen pictures. I've been sending some of my we call it bird dogs, people that go see the properties for us. That's what we call it. It's like when you're hunting, you have a dog that once you shoot the bird, they go get the bird. That's what a bird dog is. They go hunting, right? So I have these people going to see properties. They're like, Bruno, it's nothing like the picture. It's amazing. It's amazing. So never believe the pictures. Not only that, some realtors, what they do, what some realtors do, is they get the panoramic cameras or their phone with a panoramic view. They go to the corner to take the picture, and now the room looks like it's huge. Yeah. And then you get there, you're like, wait, how do I get into this room? Anyway. All right. Listings, listing agreements. Agency relationship for listing agreements must be listed in the listing agreement. It has to be there. Okay. Oh, and I just got the reply to that email. We're good. Remember I said I sent an email, hey, per our conversation, whatever. Yep. She just said, no, that's exactly what we spoke about. Everything's perfect, nothing left out. Now she's in trouble if she messes up. All right. What is a listing? Advertising somebody's property, right? For sale. We have to stipulate in the listing what type of agency relationship we have. What agency relationships can we have with the seller? With the seller, what type of agency relationships can we have? I'm still not talking about what type of listing. We're talking about agency relationship. What type of agency relationship can we have? Dual agency. Masha just goes for dual right there. What's up with you and dual? Okay, dual agency. There's no general agency here. We can have a buyer agency with a seller. I'm asking with the seller, what type of agency relationships can we have? We can have disclosed dual agency. Yes. What else can we have? Seller agent, right? And transaction. That's it. Mr. Seller, I can represent you. Or if I find a buyer, I can represent both of you. Or as a transaction broker, I don't represent either one of you. I'm just facilitating the transaction. That's it. Okay. I'm not asking, guys, you need to pay attention. I'm not asking what type of listings. I'm asking agency. Okay. If I was asking the types of listings, now, Mary, now you can say exclusive right to sell. Thank you. What else do we have? We have exclusive agency and we have open listing. Isn't there one missing over here? There's another type of listing, right? Net listing. But why isn't it here? Say louder. Because it's illegal. Correct. New Jersey does not allow net listings. Okay. Now, question, real quick. What is an open listing? Let me know in the chat. Open listing, what is it? Anyone can find a buyer. Thank you, Masha. Multiple brokers. Thank you, Elizabeth. Great. No obligation. Absolutely. Elvira just go committed, engaged, and married. All that for open listing? All of those? Only the procuring broker gets a commission. That's true in all of them. The point is, I'm open to multiple brokers looking for properties for me, for buyers for me. That's what it is. I'm open to all of them. Okay. But just like in any of them, only the procuring party gets paid. Okay. So if I have 100 agents looking for properties for me because I asked them to, but only one brings a buyer, that's the only one that gets paid. Right. Now, oh, we're getting to that, Masha. Yes. Then we have exclusive. There's two exclusives. What does it mean to be exclusive? Like there's open listing and then there's exclusive. What does it mean? Only one agency. Yes, only one broker. So when you see exclusive, very, very important, because a question could say any broker. If it says talks about any broker, automatically it's an open listing. If it says a broker or one broker or the broker in the question, automatically it's exclusive. Now we need to know what type of exclusive are we? Are we engaged or are we married? If you guys remember, if it's engaged, it's exclusive agency. If we are married, it's exclusive right to sell. Is somebody there? No, exclusive right to sell. Okay. Now, what does it mean, exclusive agency? What's the difference between these two? Go. In one, the broker, what? What's the difference between these two? It's only one broker. Only one broker. What's the difference?
Broker gets commission whether or not
Yep.
the seller
Mhm.
finds their buyer.
That's it. In one of them, the broker gets paid no matter who brings the buyer. So if the seller brings a buyer, the broker still gets paid. Which one is that? Which one? Very important that everybody knows. I want everybody to answer. I know some of you already wrote it down, but it's very important you guys know because guaranteed to be a question in the exam. Whether it's the school or state, it's guaranteed to be a question. If the broker gets paid no matter what, which type of agency is this? There's only three. Which one is it? No, you're right. There's only three types of agencies: exclusive right to sell, exclusive agency, and open listing. So, no, there's only three listings: exclusive right to sell, exclusive agency, and open listing. Which one of these says that you get paid no matter what? The answer is exclusive right to sell. The agent gets paid, the brokerage gets paid no matter what. The buyer, the seller can bring a buyer, you still get paid. In exclusive agency, it's only one broker representing the property, but if the seller brings a buyer, the broker does not get paid. You got to be clear about these three because I guarantee you there will be questions in the exam. Guaranteed. And it's as simple as you understanding what each one of these entails. So, exclusive right to sell, the broker, one broker gets paid no matter what. Exclusive agency, the broker gets paid if the seller doesn't bring anybody. Okay. Open listing, anybody can get paid as long as they bring the buyer. Does that make sense? Okay, so you got to remember that. All right, next. Seller listings. We got to have a beginning date and ending date, obviously. We got to have the list price, the broker's compensation, and what are we splitting with anybody that brings a buyer? So the cooperative listing, okay? Got to have the MLS authorization and which MLS we're going to put it on. Got to have a commission notice that says if commission is negotiable. You guys already know this. The seller must acknowledge the CIS. You guys already know. There has to be a statement with a broker or agent relationship. You already know that. What about this one? Attorney General memorandum. We have to put in every single listing a copy of the Attorney General memorandum that says you cannot discriminate. Okay, every seller must be aware that they cannot discriminate. Okay. All right, we're gonna skip this. Dual agency. You guys already know that dual agency, again, as a review, dual agency, there has to be informed consent. That means the seller and the buyer must be aware that you represent the other party, and they must be okay with it. Okay. Net listing, you already know that it's illegal in New Jersey.